people, and this is Supreme Decisions coming to you with another episode of Latin in Law on the campus of the University of Texas, El Paso. You know, the UTEP two-step. And as you can see and definitely hear, the birds are chirping, the sun is out, and I've got my drink so I can stay a little bit hydrated and not slur and cough and choke up on what I'm talking about, because today is important, because I hear this more often than anything else, and it's a judge entering a plea for you when you go to court, or you're not entering a plea because you are doing something such as challenging jurisdiction, and it's called Sua Sponte, which means of his or her own accord. There are also other facets of this, and it's known as Nostra Sponte, and it's generally heard, the latter, in appellate court when the action is taken by a multi-counsel judge. Sua Sponte is generally taken without the prompting from either party, or like I said, it is done when someone is generally challenging jurisdiction and possibly have entered a motion of special appearance. This is one of the things where I've said it time and time again, where you must file an entry of appearance to note that you are representing your own interests. The entry of appearance is the staple of all motions. A special appearance is a generalized motion after the fact. When you're doing this, there's a process to everything, and I'm trying to offer an opportunity to correct or even learn the proper motions to put in at the proper time. And generally, one of the other statements or one of the other instances this is done, it's when someone has either put in a general motion of appearance or have not put in a motion at all, and they're not entering a plea, so a judge does this for you. So what happens when a judge does this? You have grounds to have this case removed before this judge and placed in front of another judge, or you have grounds to remove this case to federal court. Why? Because it is a conflict of interest. A judge cannot practice law from the bench. It is a violation of their oath as well as your civil rights. I'm going to say that one more time. It is a conflict of interest because a judge cannot practice law from the bench. It is a conflict of interest. And in some cases, you will have an instance of Carlisle versus United States, 517 U.S. 416, 1996, where it describes a district court or state court could not move Sua Sponte to grant a judgment of acquittal or notwithstanding the verdict to remedy a late filing of the equivalent motion. Basically, a judge cannot practice law from the bench, but there is a Latin term for it. So remember that. You got a couple today. We only talked about one, and I'm also going to place Carlisle v. U.S. in the somewhere in this video. So remember, Latin in law, we're going to keep moving because Latin is what moves the court. And always remember to follow the 3 steps I put forth in the previous video. Until next time, and keep donating.
Do not try and bend the spoon. That's impossible. Instead, only try to realize the truth.
What truth?
There is no spoon.
There is no spoon?
Then you'll see that it is not the spoon that bends, it is only yourself.